This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Gary, welcome back. How was it?
Mark, did you seriously just send me something for the show while the intro music was playing?
You know, I didn't want you to feel like you were just going to soft roll from your vacay into the show.
Nice. Yeah. The 2 days that I took off was luxurious. It was I had a very good time. Thank you very much for allowing me a little break. Went out to Arizona with the family and we had a lovely time, even though I would be smarter than to schedule an Arizona vacation in the middle of August.
I was going to say, what were your options? You wanted to go to the Mojave Desert or Palm Springs or Vegas or Arizona. You were trying to see if you could. Well,
I'm a lowly podcaster. I don't plan things too well. So I have a friend who lives out there and he invited me out and that was the time that worked out. So we went and we enjoyed and we stayed very much poolside or in air conditioning.
That's smart. Kudos to you. I haven't told you this. There were some people that I hadn't seen for quite a while over the weekend. And one of the guys who I don't think I've seen him in 20 years, I mentioned he's a Reasonable Doubt listener. And
oh, wow.
And I said, well, that's great. And, do you miss Adam? And he says, Adam who? And I said, well, and I kind of gave a little thumbnail sketch of the, because he had, I don't want to throw shade anywhere, but he fits the mold for somebody who would be a devotee of the Corolla show. And his point was, you mean there was somebody before Gary? So I thought, that was paying you a high compliment.
That's very sweet. Yeah, absolutely. And no, certainly no shade thrown towards anyone. We love and miss Adam, but that's great to hear that there are people who are new enough listeners who don't necessarily know the whole lineage of the show, which is heading towards a decade at this point.
Yeah, I think it is. I think knocking on the doors at 10 years. So it's great to be here. One of the things that I saw, which I just sent you, and I apologize because I meant to send it earlier. You want to, you obviously have not read it yet, but do you want to just give kind of the headline to it?
The headline says Jack Smith can still hurt Donald Trump per an attorney.
And it's a article about an op-ed piece, apparently, that Ellie Honig wrote for, I don't know where, maybe he posted it and then Newsweek covered it. And it was interesting to me because it
appears to be a blog on cafe.com.
Yeah. And the interesting part about that is that I would have to disagree if I'm prognosticating what's going to happen and what the thesis, if you will, by Ellie was that Jack Smith, I think he says in his post, there's a 0.0% chance of Trump going to trial before the election. That is absolute. He's speaking truth there. But he's talking about the evidentiary hearing, which the reading of the U.S. Supreme Court would, I think a fair reading necessitates, meaning that the trial judge will have to do an evidentiary hearing and make a factual finding as to what is a official act versus what is an unofficial act. Now, the reason I bring that up is since I think reasonable minds can agree as opposed to disagree that there is 0.0% chance of a trial prior to the election. Having said that, what are the odds on an evidentiary hearing? One of the things that I did not see in that article, and I just skimmed it, and truth be known, I haven't read the blog post. Jack Smith did, in fact, ask the court, meaning Judge Chuckin, for a press pause while he consults with the DOJ. And the fair reading of that is that the DOJ guidelines clearly call for you don't do anything in that 90-day window before the election. And obviously, we're already within that 90-day window. So I cannot imagine that the DOJ would bless the idea of having a evidentiary hearing where they call Mark Meadows, they call Mike Pence, they call various other people, and have a judge make a decision on whether or not an act that was committed prior to Jan 6 or surrounding Jan 6 and that indictment is official or unofficial. And so I would say that article is a little bit of intellectual catnip for people who are following it. I don't think that there's any chance at this point that the DOJ would step forward and say or bless the idea of Jack Smith going forward on this.
Yeah, and it sure seems like something like that, even if the aim was to aid one campaign, could just as easily aid the other campaign, because that kind of thing would just, supercharge, I think, both campaigns. You might put the Harris-Walz campaign on the defense a little bit, and Trump would talk about nothing else for the next 45 days.
Correct. And I think it would fit. I hadn't even thought about it from the political perspective. I was thinking about it from the pure legal, but from a political perspective, it definitely has. It could play out as the law of unintended consequences.
Yeah, I think it probably would. And I think that it would really alter the state of both campaigns. And I think you would have both camps very unhappy with it ultimately, for different reasons. But ultimately, I think that both political operations would be very displeased.
Yeah, I've said this, speaking of 10 years, for the entire 10 years I've been on this podcast, that the idea of independent counsels who were eliminated back in whatever it was, 98 or 99, the idea of special counsels, which have been employed ever since, their time has passed. There is no reason for them. And it's just, it's astonishing to me that they still exist in this world where we've seen all of the mischief that they cause.
Yeah. And, we also have the ruling looming that, calls into question whether or not their appointment is even a legal practice the way it was done in this case. Correct?
Correct. I mean, you as you know, I've got that case out there. It's pending a ruling. And so it'll be interesting to see. There's another one that is pending also in this district. It'll be interesting to see what happens there as well. I think Clarence Thomas in his concurrence called it exactly right. There is no authorization for this. And the idea that you can have these things, these extra prosecutorial appointments, to me, just runs counter to any constitutional framework.
So we have another case out of the Florida area that involves Disney and their attempt to send a wrongful death lawsuit to arbitration. And it's really pretty crazy what they're trying to argue there. Do you want to break that down, or you want me to give
why don't you try to explain it? Because it's really a fascinating kind of intellectual exercise. But I can understand intellectually what's happening here. We'll put aside for the time being the public relations aspect of it.
Sure. So a big caveat to the best of my understanding, because I'm not all the way in the weeds on this. I've read a little bit about it, but there was a couple who visited Disney World and they dined at the Raglin Road Irish pub, which is part of the Disney owned property. To my understanding, it is akin to something that would be at downtown Disney here in Anaheim. So it's on the Disney property. It is not owned by Disney. It is owned by an LLC called the Great Irish Pubs of Florida Incorporated, and they tout themselves as being sensitive to allergies and to intolerances. This couple dined there. Apparently, the wife in the couple ended up dying as a result of an allergy that she contracted as a result of something in her food, and the wrongful death suit.
I remember correctly. Also, she or the table did alert the server to the allergy as well. You know how when servers traditionally say, does anybody have any allergies? And they did speak up.
They did speak up, and the restaurant publicly touts that they are friendly to allergies and to sensitivities. And in the lawsuit, they state that they picked the restaurant as a result of that that advertisement, that the restaurant is sensitive to those things. They spoke up. There was an unfortunate incident. They died, and the husband has sued for wrongful death for $50,000. I've read $50,000 in some publications. In other publications, I've seen $50,000 or more. And I don't know if that's just I'm
going to take a wild guess and say it's a jurisdictional hurdle.
I completely agree. That's exactly what I was just trying to figure out how to say. Disney has gone on to...
Now, mind you, they named Disney and they named the restaurant, is my understanding.
That is correct. That is correct. Disney has gone on to say that as a result of the fact that they purchased tickets to the to Disney World, and as a result of the fact that they signed up for a free trial of the streaming service Disney Plus, that as a result of the terms and conditions of those two things, this should not be allowed to go forward in court and should be moved to arbitration. Now, a lot of people are focusing on the Disney Plus aspect of this and are saying that the fact that the terms and conditions of Disney Plus, that are, I believe, 88 pages when printed in a standard font size, have a stipulation that any disagreement with Disney will be sent to arbitration. And a lot of people are saying that that's unreasonable. I saw a study out there that said that 99.6% of people do not read the terms and conditions of an average internet service like Disney Plus.
You think that's a conservative estimate?
I'd say that's low. I mean, I'm not sure I can think of a person I know and could contact that has ever read through the terms and conditions of a streaming service.
I can think of a person that I would suspect. I mean, I've had close encounters with lawyers who are on the spectrum who would strike me as the type that would actually read that. But I still think if you're taking the entire database of the population, 99.6 still strikes me as a conservative estimate.
I couldn't agree more. Yeah, I believe that you know someone who might have read, through the terms and conditions when they bought a new computer or something like that. But for me, I can't think of anyone who has taken the time to read more than maybe a paragraph or two of that kind of thing, because it's designed to be daunting, and it's, crazy legalese. It's designed to be hard to read and hard to understand. And, ultimately, if you want to watch a movie, you're not going to go through 88 pages and decide, no, that arbitration clause is not something I'm on board with.
Yeah, I'm with you. It's but I understand what, this has been really a raging argument in the law. I am fighting these clauses when it comes to conduct that is outside of or against public policy. But so far, that's been somewhat of a heavy lift. I can't get in the context, and I won't bore you with the context of it, but in the context of where we're fighting it, nobody wants to deal with it on the merits. And part of the problem for that is when you have, and now this is the cynic in me talking, when you have courts that are so overburdened and they've got the opportunity to send something to arbitration, the cynical side of me would say, well, that's a wonderful way for a judge to exercise calendar management, which is throw it to the arbitrator, say that even the decision of whether the thing is arbitratable, meaning should this be arbitrated, did the agreement cover it, many judges will send that to the arbitrator as well to decide. I have mixed emotions about that as well, because if the whole idea is that you shouldn't be subject to the arbitration clause, then why are you saying I'm going to punt it over to the arbitrator to make that decision? That seems to defeat the whole purpose. But from a resource management, that's where I say the cynic comes around.
Yeah, I can see both sides of it, too, because, these things need to have terms and conditions. And I think that a politician who came in and said, we have to make these plain as day and easy for the average American to read and understand, I think that would be wildly popular. But it's not very practical, because there is a lot that has to go into these things, and they have to be laid out in such a way that is, frankly, just something that most Americans, I believe, are going to skip by. And that's just kind of the world that we live in, unfortunately.
Yeah. Now there's a, and I didn't send this to you, and it just occurred to me. And let's see. Have you been following the propositions here in California on the retail theft bills in Prop 1 and Prop 36 in the news conference that was here? Because it appears that there is and I've seen what I'm referring to is this package of smash and grab bills.
Yes, I believe there were 5 of them that were signed. I have not been following them to the extent that I've read the propositions, but I have seen the news stories, and I have been following the attempts, at least by Governor Newsome, to change the laws to sort of try to curtail some of the retail theft and some of the things that have been driving businesses out of a lot of large California communities. We've seen a rash of large retail stores and stores that would reside in malls kind of leaving certain communities. I believe In-N-Out closed their first location up in the Northern California area. It's the first location they've ever closed in the history of the company, because they were just they were having too much trouble with the residents of the community and with the people experiencing homelessness, who were just plaguing their business and causing increased security costs.
Yeah. And so the juxtaposition with Prop 36, and if you can find this little soundbite, that's the one I was referencing. That's how I got into it. So the legislature has passed a whole nexus or group, bundle of bills that enhance the penalties for repeat offenders, things of that nature. At the same time, on the ballot is Prop 36, which would increase, as I understand it, the penalties for basically kind of a modification of the previous Prop 47. And now there's some talk about Prop 36, Prop 1, and Prop 47, and the interplay between all 3 of them. And people are calling it, I mean, part of what I've read is this a sleight of hand? Is this a kind of a bait and switch on the voters? If you could find that press conference, Gary, and even if you want to press pause for a second, because I've been totally unfair to you.
No, it's okay. It's Gavin Newsome kind of railing against Prop 36. Is that what you're referring to?
Right.
Yeah, I think I have it here. Let's see if we, again, I'm doing this on the fly, so my apologies. And if this is not it, you can just tell me and we will pause down for a second and I'll find the right thing.
I mean, they're lying to you. They're lying to you. That initiative has nothing to do with retail theft. This has everything to do with retail theft. That initiative is about going back to the 1980s and the war on drugs. It's about mass incarceration. And don't take my word for it. Look at the independent legislative analyst who said it will cost billions and billions of dollars. Not $1 is attached to Prop 36, not one. Any of you that are fiscally conservative, you should be screaming from the rafters.
Well, first of all, Governor.
Okay, so that appears to have commentary stitched into it. So I've gone ahead and stopped that.
You want to see? Let's see the commentary. I'd love to see the. Do we know who this is?
I have no earthly idea who this is. Like I said, doing this live on the fly, just was what I came up with on Twitter.
Well, first of all, Governor, if you read what the analyst said about Proposition 36, it does partially have to do with retail thefts. If you have any semblance of reading comprehension, you can see that it gives people a higher sentence if they've been convicted of retail thefts previously, even if they stole under $950. And guess what?
They're lying to you.
People are tired of the crime here in California. Small business owners. Look, I've got family members that own businesses that have gotten robbed where there was no one to go after these criminals and prosecute them because of the soft on crime policies in this state. Literally 3 7-Elevens were broken into after you gave that speech. So what do you think you're doing there? You're signing 10 bills that have had no input from the public. Instead, we're taking to the ballot box because you don't want to make the reforms that need to be made. And unlike what you're saying, there is room for rehabilitation. Make crime illegal again.
All right. So that appears to be someone named Max Bonilla, who has 14,000 followers on Twitter and goes by the handle outrageteen_. And just based on the first few tweets that I see on his timeline, I'm going to call him a right-wing California influencer who is, obviously young and has been on Twitter since February 2021 and has amassed somewhere around 14,000 followers.
Interesting. So good for him that he's voicing and doing a little statutory construction. He's probably too young to remember the 80s and the
definitely
and what that the build the prisons as fast as we could ethos that clearly did not work here. There is a pendulum swing, as you and I have talked about a million times. We're in that pendulum swing back to the 80s and the 90s. I just hope, if Drew were here, Drew and I would talk about this idea of a thesis, an antithesis, and a synthesis theory of history, and what that means and what the origins of that are. But part of what I would point out is there is a way to calibrate this. There is a way to deal with this that so far seems to have eluded both the legislature. And part of what he hits on is that he's saying that the legislature, this young man, the legislature is not listening to the people. So therefore, that's why you have to do a proposition. And that arguably, California's got this rich history of having propositions on the ballot, which will kind of go around or do an end run around the legislature. From a civic standpoint, that makes sense if you're dissatisfied with your legislators. There's a school of thought which is, well, then you should get rid of your legislators and make them responsible or tie them to what is being passed in Sacramento. There's also the idea, well, if you can't do that, or if you're disgruntled, that the public can govern by proposition, so to speak, which is what he's basically arguing for.
Yeah. And, it's a good point that you bring up. I think maybe we should effort to have Drew back sometime soon, because it's been far too long since we've heard from him. And he certainly has valuable insight or opinions, I guess would be the better way to say it, on these big issues that are plaguing the state.
I was thinking about him and tweeted over the weekend a lot of death in our world recently. And one of the people who's passed away untimely is Craig Simon, who had offered his home for Drew's son to get married in. Jake, my son, was in the wedding, and Craig passed away this month. And we've got a photo somewhere that I tweeted out of Craig that who went by the nickname Subro King, for he was very much into the wildfire and the fire litigation, and was generally regarded as a expert in that area, and had a great breadth and depth of knowledge. Yeah, that's it. There's the father of the groom right there, and that's Craig next to me, who passed away, and may he rest in peace.
Yep, absolutely. I saw Susan tweeting about that and talking about it on social media as well. Seems very sad, but we would certainly love to have Drew back and hear from him on a whole host of topics. So Mark and I will work behind the scenes to try to make that happen in the weeks to come.
Thanks, Gary. Welcome back. Glad to have you here. I am presumably in an air-conditioned room.
Yes, Arizona or California. I try to stay in the air conditioning when I can.
Good to have you back. See you later this week.
Thanks, Mark. See you soon. Bye-bye.
Thanks for listening to Reasonable Doubt. Subscribe on YouTube at youtube.com/Reasonable Doubt Podcast.